Franz was talking about branding and patent protection. Branding is probably a lot more important than patent protection. In the United States, it's easy to brand. You come up with a name, you start using it, you have some legal rights to it. Most of the rest of the world isn't that way. Most of the rest of the world, you have to actually go file a trademark application to try and protect your brand before you actually start doing business in the country. And if your business takes off and people are recognizing that brand and you don't have it protected in certain places, it can be a big deal. We had a client a year or so ago that hadn't protected their name in Brazil. They weren't doing they weren't marketing in Brazil yet, but it was a place that they wanted to go. Unfortunately, somebody else had already stepped in and taken the company's name, and so it's a big deal. They have legal fights about who gets that rights to that name because it is a recognized name, and it's an iffy situation. They may not give rights to their own name in Brazil because they didn't take the appropriate measures at the outset to protect those rights. You were talking about contracts. Most of the contracts I see are for emerging companies, and they're trying to market their technology to other companies. Most of the contracts I've seen from outside the United States, from companies outside the United States, they're perfectly willing to write the contract in English. And the English speakers in a lot of these companies are very good, and the contract will be very similar to a contract between two U.S. entities. Unfortunately, a lot of times the heavy hitters are based outside the United States, and they want to have that contract decided in terms of their law. And again, you have to rely on those legal relationships outside of the United States and the expertise outside of the United States to deal with those types of issues, with the branding issues, with the patent issues, everything like that.